All right. Hello, everybody, and welcome to the webinar, Future Planning for Children with Disabilities, a disability planning attorney's perspective on planning for families with special kiddos. This webinar is a partnership and is brought to you by the Exceptional Children's Assistance Center and for Advocates for Medically Fragile Kids NC. And our presenter today is Bailey Liipfert, and I will let him introduce himself in just a moment. My name is Christy Moore, and my title is way too long, but there it is. I'm with the Exceptional Children's Assistance Center, and I will let Jenny introduce herself.
Hi, welcome. I guess good afternoon now. I'm Jenny Hobbs. I'm one of the co-founders for Advocates for Medically Fragile Kids NC, and I'm just really excited. We finally are doing this, and like Billy and I talked about for probably a year. So I think he's gonna give us some really great information, and I'm excited to learn more.
Yes, and thank you, Jenny. We just want to thank you so much. Jenny is who connected me to Bailey, and we are very grateful that he was so willing to present on our platform and share all of this great information with all of you today. And then also Thursday at 7 to 8:30, we will be doing this again, and that session will have Spanish interpretation as well. And just a plug for Advocates for Medically Fragile Kids NC, if you have not visited their website, I strongly encourage you to do so. It is a fantastic resource for families and professionals. The information that they have on there for Medicaid and Medicaid waivers in 1959 and all the things is just incredible information, super easy to understand. So I highly suggest, and Jenny, if you want to drop a link to your website in the chat periodically, that would be fantastic. Great resource. Okay, so a little bit of housekeeping before we get started. So this webinar is being recorded, and a link to the recording and the slides will be included in a follow-up email that will be sent to everybody who registered. It'll take us a little bit to get the recording uploaded and stuff, so I hope to have that out by the end of the day today. If not, it will be tomorrow morning. And also the recordings will be posted on ECAC's YouTube channel and Advocates for Medically Fragile Kids NC's YouTube channel as well. We're planning on having a lot of folks joining us today, so please put all of your questions in the Q&A section that's located at the bottom of your screen, and we're going to answer those at the end. But you are welcome to put your questions in the Q&A as you think of them, and then we'll go so you don't forget it. And then as we go through at the end, if it's something we've already answered, we might just recap it real quick. And this is just to give Bailey time to get through all of his material that he wants to share with us today. And just due to the large number of anticipated attendees, we're not going to be able to unmute participants to talk. But again, we do welcome questions and would love for you to put those in the Q&A. If you have any additional questions or questions that are very specific that pertain to your personal situation, where maybe we would need to ask more personal questions to get more information. We don't want to discuss super personal information on a public forum like this. So feel free to send your question to me, and there's my email address, or to Jenny. And if it's Bailey we need to connect you with, we will do that. And Jenny will share her email address in the chat as well too. Just want to let everyone know that towards the end, I'm going to launch a quick evaluation poll. I think it's 3 or 4 questions. We collect this data for our grant reporting purposes and to make improvement and to create content that meets the needs of families and professionals across the state of North Carolina. And we really, really appreciate your feedback. So with that, I will stop sharing and I will turn it over to you, Bailey.
Thanks. Appreciate it, Christy. All right. So my name's Bailey Liipfert, and I'm a certified elder law attorney practicing at Almond Spry in Winston-Salem, North Carolina. I have a certification. I'm a certified elder law attorney, and we call that CELAs, by the National Elder Law Foundation and the North Carolina Board of Legal Specialization. And just to explain sort of how I got to be a disability planning attorney. I started practicing law about 34 years ago after graduating from Carolina, go Tar Heels, uh, with a degree in Soviet area studies and Russian literature. While I was in college, I started volunteering as an EMT in Orange County here in North Carolina in Chapel Hill and Hillsborough areas. And after attending law school, I started practicing in a firm that had a lot of estate planning as a practice area. And having been an EMT and gone into a lot of people's homes, I saw a lot of situations, especially those involving older people and people with disabilities who uh, would run into health issues that we would have to transport to the hospital or treat in the field. Um, and being a young lawyer, I felt like something was missing from my life, not doing the EMT work. And I quickly noticed that there were a lot of needs not being met within my community. The first ones were phone calls that I would get from folks with spouses with Alzheimer's disease. My firm sent me off to learn about healthcare powers of attorney and living wills, which back 34 years ago was a new topic and a new item that we were discussing with our clients. And fortunately, I found out that there were attorneys that were helping people with issues related to public benefits, and that there was an area of estate planning that I could work in, that I could help the same kind of people that I'd been helping when I was working in the back of my ambulance. And uh, very quickly, there weren't many people helping folks with those kinds of issues back when I started. So it pretty much gobbled up my practice. And at first, it was mainly the families with parents with dementia going into assisted living and nursing facilities. And soon thereafter, I started running into a lot more families with children with disabilities. And over time, that's really all I've been doing is working with families along this spectrum of having kids with disabilities, but also families that start to be struck with the illnesses and issues that sometimes come later in life. And in speaking with you all today, I'm going to be focusing myself on really the timeline of what can happen from the time a child's born till a child passes away. And it really covers just about everything that I work on and that we elder law attorneys typically help our clients with. Now, unfortunately, uh, elder law hasn't really been updated to expressly state that we also work with families with kids with disabilities. And I really think at some point we need to look at changing the name of our organization, the National Academy of Elder Law Attorneys, because most of you probably wouldn't have realized that elder law attorneys would be the attorneys that would be most likely able to help counsel you along the path of life with a child with with disabilities and with needs that some other kids wouldn't have. Uh, I do want you to be aware of a few organizations. The first one I've already mentioned is NALA, the National Academy of Elder Law Attorneys. Um, Another is the Special Needs Alliance. I'm a member of the Special Needs Alliance, and you can find members at the Special Needs Alliance .org website. Um, Attorneys that belong to the SNA, Special Needs Alliance, have been vetted before becoming members And so you can count on there being a knowledge level amongst members of the SNA that might be greater than just the typical attorneys. There's also the North Carolina Bar Elder and Special Needs Law section. And in North Carolina, we have updated our name to include both. Unfortunately, we really don't have a searchable database, but most of the folks that would be practicing in this area would also be members of NALA. And you can search for NALA members on the NALA website, as well as the Special Needs Alliance website. If anyone needs help with locating somebody that can help them either in North Carolina or in other states, feel free to get in touch with me. Now, let's start going through key transition times for families with kids with disabilities. And from from birth until age 3, folks that I would refer you to, two of the folks that I would refer you to are the sponsors today. The ECAC and Advocates for Medically Fragile Kids, NC, have wonderful resources on their websites, and I'm referring other attorneys to these websites myself. And I have an associate attorney who's just started practicing law and got eligible back in September. He's already starting to look closely at resources that you can find. In your communities, you should have family support networks. And if you've got a very young child, that's a good place to start with advocates who've been there that are adults, parents that have kids with disabilities. And that's a good place for you to start. And thanks to ECAC and Advocates for Medically Fragile Kids for sponsoring us today. Now, from age 3 until age 22 is the time when kids are going to be involved in the school systems. And it's an important time. During that process, you might have to be self-advocates, and especially ECAC is going to have good resources to help you with dealing with those situations. There are IEPs that many of you are familiar with, and other ways to approach school systems, such as 504 being the Rehabilitation Act being a way to seek accommodations on the part of the school system and working with your children facing disabilities. Also, we do have post-secondary school education programs and potential education options that start in the school systems and can last beyond. But those early years before it turning age 22 are really critical. Um, Now, I'm not going completely in age order here, because another a key transition is when a child turns 18 years old. Uh, for one, a child at 18 is no longer a child and can make their decisions legally themselves. If they're incapable of making decisions, we'll talk a bit about what options there may be, and guardianship is one of those options. To me, it's really not the preferred option if there are other options that we may be able to turn to instead that would be less restrictive. So I'm not a believer in every child with a disability at age 18 needs to have a guardian, but it is something that needs to be discussed. How can that child uh, make decisions or name people that can make decisions in the event that they need help with making decisions? Another big transition is that many families, because of assets and income that they have coming in, aren't able to have a child be eligible for Medicaid or SSI until the child turns 18 years old. At age 18, Social Security and Medicaid no longer deem the assets and the income of the child to the child. And at this point, SSI is a potential option. I'm going to speak with you a bit about how critical SSI can be to the later years of a child with disabilities uh, lives. And there are many families that I don't think are aware of what they may be missing out on, and may feel like, well, we never needed SSI and a check from the government before age 18. Why do we need it now? And I'll try to explain to you why I think it can be really critical for us to have that SSI for many kids. Another key transition time is really based on when a parent either dies, becomes disabled, or retires. Uh, at the point where a parent becomes disabled, dies, or retires, the child may be able to draw off of that parent's work history. And if they're drawing SSI, they're either going to continue to draw a little bit of SSI plus a childhood disability benefit, which is actually based on the parent's work history, or the parent's work history mean that they'll have a check that may be in excess of what SSI would pay at all, which might seem a little scary if you're parents that have been having to keep a child on SSI under $2,000 of assets at the end of every month. But there's some ways that you can make it through that transition if you haven't already. And that to me is going to be one of the most important topics for us to be talking about here. At the point where the parent uh, starts drawing their Social Security, the child, after receiving a check for 24 months, and typically it takes 29 months for you to actually start receiving Medicare. But in addition to Medicaid, if the child has Medicaid, the child would be eligible for Medicare as well. Um, and that would be a lifetime benefit that they would be drawing based on the parent's work history. Now, I'm going to mention this now, but I'm going to go into it in more detail later on. But if a child is eligible for SSI and loses the SSI because they're drawing the larger check based on the parent's work history, there's a special Medicaid rule called the Disabled Adult Child Pass Along, which allows the child to retain their eligibility for Medicaid, even though their income may exceed 100% of the federal poverty level, which normally would lead to great troubles in being able to keep Medicaid. So having SSI at the point where a parent dies, death and disability, we have some control over that, but death can happen at any point, and the child with a disability has to have become disabled prior to age 22 in order to draw for the parent's work history. And many of the kids that you have would meet that criteria. But if they don't have the SSI at the right time, that special Medicaid rule doesn't apply, making it very difficult to access Medicaid. Now, the Medicare will be there once the child's eligible for that, but Medicare doesn't cover everything that Medicare does, and especially the kind of benefits that you have with our waiver programs like CAPC or the Innovations Waiver are not provided by Medicare. It's my dream that one day Medicare might cover those things and that we wouldn't have to live with all the convolutions that we live with these days. But at this point, we probably wouldn't be able to. So just to give you an example, if a child were to draw $1,400 a month in childhood disability benefit, um, without the DAC pass along, that entire $1,400 would have to be spent on medical expenses, except for $262 a month. So on a monthly basis for a child that would be eligible for the innovations waiver, the entire $1,400 uh, minus the $262 would be going to pay for expenses that the innovations waiver would have paid for if the child didn't have to meet a deductible. So if I'm going to explain this multiple times, and there's a whole slide devoted to it, but I want to make sure I say it multiple times. And there could be some parents on this call that may have lost their child's eligibility for Medicaid when the child started drawing off of their work history. And sometimes this is due to mistakes that were made at the departments of social services. So always get a second opinion with DSS or with a disability planning attorney. I've actually had folks that have lost Medicaid for years, spotted the issue that the DAC pass along was missed. And in one case, it was 15 or 20 years of no Medicaid. And the Department of Social Services involved apologized, but there's really no way you could make up for 15 to 20 years of lost benefits. And so that to me is a big issue that we run into. Another key transition is somebody with a disability can decide that they would like to be able to work. And there are a load of options available to help people with disabilities start to work but not lose their benefits. This includes incentives to help people that are eligible for an SSI check be able to stay eligible for their SSI, but still have additional work history and work income, but also for folks with Social Security disability. A good place to start is talking with Social Security and vocational rehab. And there are a number of resources, and I'll go into a little greater on this later as well. And I'll give you an example now of a friend of mine. He's also a disability planning attorney from another state. His daughter has cerebral palsy. And when she was in her late teens, she started helping her dad out at the office. She's not capable of being able to hold down a full-time job, requires a lot of assistance with her ADLs. Um, but she's able to work in her father's office and has helped with scanning and organization of his files for years. And she began working and earning a little bit of money. And by the time she got to her mid-20s, to her father's surprise, she had enough of the work history herself to actually start drawing an SSD check, not based on her dad's income, but based on her income. I think at the time, in order to get credits she was probably having to have about $250 of income, typically on a monthly basis. And it all added up to enough that she started drawing a very small SSD check. Now, remember what I said earlier. If you're on SSD and you've become eligible, it actually takes them 5 months before they start paying you a check. Then 24 months after that check starts rolling in, uh, you become eligible for Medicare. So his daughter in her early 20s, in addition to the insurance that she had through Medicaid, also had Medicare, which opened the door to additional potential doctors that she could work with in her community that she might not have had access to, because there are more doctors that would be willing to take Medicare than are willing to take Medicaid. Um, so it can be a real benefit to work, even if you're not able to work as many hours as it would take to be able to live independently. Now, her dad has started drawing Social Security as well. She's still able to draw some of the childhood disability benefit because the income based on her father's work history is higher than the income that she's earning based on her SSD. And so she's in a better position, and will be in a much better position when her mother and father die, because she'll continue to have additional income that will make it easier for her and her future caregiver to take care of her in their household. So don't consider that a child might never be able to work and that that's the only way to be able to protect eligibility uh, for benefits going forward in the future. We really have better options available, and the Social Security actually posts annually a book called the Social Security Red Book, which actually covers all of those incentives in one place that enable people to be able to uh, work independently. Another key transition time for children with disabilities is when they receive inheritances. And the best option is for you to plan for you passing away and making sure that you've either built a special needs trust either into your wills or into a freestanding special needs or supplemental needs trust. You might hear special needs trust, you might hear supplemental needs trust. Both really mean the same thing. Um, and I'm going to go into more detail later on. This is just sort of my overview. Um, Now, if there is no plan in place, what happens? Um, there's a lump sum of money that goes to a child with a disability. If you don't have a will and your spouse survives you, but you have assets of your own, part of those assets are going to go to your spouse, but potentially some of your assets are going to go to the child that you have with a disability. And that could cause issues with the public benefits that they're eligible for. If they're not competent, it may mean that there needs to be a guardian of the estate appointed to ask a court for permission for deciding what to do with those funds. Assuming the child's competent, they can decide where somebody using a power of attorney might be able to decide to help them with spending the money down in useful ways. They may be able to put money into something called an ABLE account, an Achieving a Better Life Experience account, that we'll talk about a little bit later on. Or, and this is what I never want to see happen, it might need to go to a payback special needs trust. And we'll talk in more detail about that too. But the payback special needs trust has to pay Medicaid back when the child passes away. and the funds really go to pay anything that Medicaid had paid for during the entire child's lifetime. So that's a trust of last resort, and it's only available for children that haven't turned age 65. And having practiced for 34 years now, I'm running into a lot of families where the parents are in their 80s and their children are in their 60s. And it's too late if you haven't done a special needs trust of your own, which I would call a third party special needs trust, either in your will or in your trust agreements to take care of that child's needs. Another issue is parents and caregivers can become disabled. And so as parents, it's important that you have a solid estate plan for yourself in order to make sure that you can cover everything for them, for those kids. Powers of attorney, advanced directives like healthcare powers of attorney and living wills can help. And there are lots of times that I recommend getting care managers involved that understand both the needs of the child, but also can help where the parents begin to suffer from disabilities. So as you get older, it's a good idea to think about those. Now, one thing you can think about when you're younger is long-term care insurance and life insurance that might have a rider attached to it that allow you to use the funds in your life insurance to cover the cost of long-term care if you or your spouse ever require living in a nursing facility or an assisted living or need help at home, because our options are much more limited as to waiver programs for older people who need help over age 65 than they are for folks that have disabilities that are a lifetime long. One thing that I often recommend is to have a plan in place to know who ought to become the caregiver if something should happen to you, and be realistic about what your options would be in that case. Now, I'm going to turn and start talking about some hypothetical situations. And my first one is Jack is turning 18 years old, and his parents have been advised that he must be declared incompetent. Jack's on the autism spectrum, can communicate orally, can generally make decisions, but his parents are worried that he might make bad decisions with money. He also might make bad decisions and run with friends that might be a wrong wouldn't 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 be the best decision makers. And I've seen times where children have made bad decisions. What would be the options that we would be discussing? First, before deciding somebody needs to be declared incompetent, we really want to look and see, are there less restrictive means of managing the situation? If Jack is able to understand a power of attorney would allow Jack to name somebody, potentially his parents, to help him make decisions concerning his money and his decision making. And if he could understand that well enough, and he could express that he would want his parents to be the ones that would help him, he might be able to sign a power of attorney. Now, depending on how well he understands money, chances are his power of attorney might be written differently by your attorney than a power of attorney would be written for you and a spouse. That might discuss things like gifting powers that might let us move assets from one spouse's name to another spouse's name for planning for Medicaid or for tax planning or for other purposes like funding a trust for the child with a disability. And one thing also that we have in our arsenal is Social Security for the SSI check can name a parent as a representative payee or somebody else who can manage the money fairly informally on behalf of the child. So the financial power of attorney would not impact the SSI. That would need to be treated the way that Social Security requires it to be treated. But the power of attorney would give parents the ability to help a child with making decisions. A lot of times when I draft a power of attorney for a child with a disability, one of the things I try to discuss with the child is both HIPAA issues and FERPA or educational issues, and we can build into the power of attorney FERPA powers, and in a healthcare power of attorney, that is a HIPAA privacy release. And so there are ways that uh, we can protect the child and still have a parent be able to step in and help them with making decisions using a power of attorney. The risk with the power of attorney is a child could decide to fire you, parent, one day if they're capable of doing it, and they could make mistakes. And if they make bad enough mistakes, that could be a justification for going with guardianship later on. But from my perspective, I'd much rather let a child be as independent as they can be with the safety factors put into place that parents and the trust planning can provide. Um, there's also a concept of a supported decision-making agreement that we now have in North Carolina that might be an alternative where somebody might be incompetent, but the courts, instead of going with guardianship, might encourage a supported decision-making agreement. And I'm hoping that we'll see more examples of that and maybe some improvements in the law in North Carolina. In some states, if you have a supported decision-making agreement, for a person with a developmental disability, the child can be protected quicker by the courts if anything goes wrong, and by adult protective services for adult children that otherwise might need a guardian, so that courts could react much quicker than they could in North Carolina. Guardianship doesn't have to be unlimited. There can be limits put on it. And in time, limited guardianships may be able to transition into somebody that's all been declared incompetent, being declared competent so they can make decisions again. Next hypothetical is about Frank and Julie Jones. Both are 60 years old and have a 35-year-old son, Jasper, who's on SSI and living at home with them in Cary. They have never done a will or any estate planning. What issues may they face? How can they plan for these issues? Well, if Frank and Julie walked into my office today, I would have them handwrite a will before they walked out the door, because I would want them at least to have a will that said that they leave everything to each other, and they could handwrite that will in each in their own handwriting. And in North Carolina, that could potentially be a valid will. Um, Back in the time that we were going through COVID and people were feeling sick, I had more than one person who hand wrote a will feeling a little bit sick with a cold coming on, just in case, because it could be that important to protecting their child. Um, you could also say, Frank and Julie could say in that handwritten will, um, if my spouse passes away, my son Jasper, uh, I'm intending that everything go to Jasper in a supplemental needs trust. to protect his Medicaid and his SSI. Now, it wouldn't be a good trust and somebody would have to figure out how to put it together, but it would give an attorney like me a fighting chance to be able to create a third party trust and have the court approve of it based on what that really super simple will said. Um, Without it, it would go straight to Jasper. And if because Jasper's incompetent, we would have to go through the court system in order to uh, in order to get permission from the court to do what needs to be done. And the kind of special needs trust would be a payback special needs trust, which would first go to pay the state of North Carolina and any other states and the federal government back for any care that was provided during the lifetime of that child. If instead of just having one son with a disability, there were two other kids in this family, instead of the money going to the other kids, it would be going to pay Medicaid back. Intestacy is the law that the state of North Carolina or the state you're living in would apply. And fortunately, the money doesn't just straight go to the state. It would go to uh, family members to a certain limit. Um, Once you get past first cousins once removed, it would potentially go to the university system here in North Carolina if somebody died in North Carolina, but it would go to spouses and to kids under under intestacy here in North Carolina. And for poor Jasper, if his parents passed away with no plan, who's going to make decisions about where Jasper is going to live? It's going to be up to the court to make those decisions and pick who's going to be the successor guardian for Jasper if he's not competent and unable to make decisions for himself. So all of those issues can be done in a well-drafted will. And by the way, I'm not encouraging everybody to go handwrite a will. That's a last resort. It would really make sense and it's worth it for you to consult with a good attorney, preferably somebody that's an elder law attorney or disability planning attorney. Um, but any attorney should be able to help you at least get better than intestacy and protect your child in a better situation and make it a better situation. Now, for our estate planning here, we're going to be looking at you doing durable powers of attorney and living wills, healthcare powers of attorney that express your wishes. In your will, we could include the special needs trust. And we could also do a trust to protect your spouse. Now, if an older couple faces a spouse with Alzheimer's or other disabilities, it may be what we need to do isn't just a trust for Jasper, but we may need to do a trust for the surviving spouse. And I'm a little faster to put that kind of contingent trust into place for my families that have kids with disabilities, because a lot of times we don't want to get around to having to go back and see lawyers again. So it could be somebody in their 40s that I wouldn't have been planning on being disabled doesn't come to see me again until they're 65. And it may be they never come back to see me. So if that person has a child with a disability and they have a spouse, I'm likely to put a contingency in to create a trust for the spouse, just in case we never had a chance to come back and do the planning. We could also do something called a revocable living trust. It's a way to keep your estate planning more private and keep the courts out of the process. Um, a will goes through a public process at the courthouse, and there are some fees, but the fees in North Carolina are much lower than they are in some other states. In North Carolina, the fees the court charges are 0.4%. Uh, and there's a cap of $6,000. So if you had $100,000 of cash and you had $100,000 house in North Carolina, the house isn't part of probate unless it has to be sold to pay medical expenses or other expenses after you've passed away. But the 100,000 is. So the court would get a commission of $400 out of the probate estate um, when the will gets probated. And that process would be managed at the courthouse, where it wouldn't have to be managed at the courthouse if you had a fully funded revocable living trust. Uh, I would consider a third party special needs trust for Jasper either in the will or set up as a separate trust. And one reason that I would set up a separate trust is if there are other people that might want to contribute uh, to Jasper's care, like grandparents, aunts, and uncles, that third party trust could be set up and other family members could be told if they want to leave anything to Jasper, don't leave it directly to Jasper, leave it to this trust that we've set up. Life planning for Jasper, I would be encouraging the Jones family to look at finding ways to get Jasper out of the home. Are there employment options? Are there volunteer options? Get him used to living as independently as he can. Would it make sense for him to maybe be living in an apartment? If he's capable of doing that, if Jasper would be moving to live with other relatives and those relatives are in other states, it might help to have a conversation with a lawyer in that state to know what the options might be there. And that's where the Special Needs Alliance can come in to uh, help us, is that I know attorneys in most of the country, and we attorneys that work a lot with families with kids with disabilities tend to go to a meeting or two. One's down in Florida at Stetson University, which is in the Tampa, St. Pete area. And so we have a chance to see each other and we hear about what's going on in other places, but it's always important to know that our waiver programs don't translate well over state lines. And it's important to know whether things are going to work well if somebody's moving to South Carolina, Virginia, California, Colorado, and so transitions are something that I like to talk about as part of the estate planning process. Um, Now, let's talk a little bit more about third-party special needs or supplemental needs trust. These are the ones that you set up for yourself with your own money. They can be done in the will. They can be done in a freestanding trust agreement. Um, the trustee has to have discretion to say yes or no to making distributions to the beneficiary. And this would be true for the trust for your child. It would also be true for the trust for your spouse. And the trustee has to be able to say no to the beneficiary in order for that trust not to count. The other thing that really needs to be there is the trustee has to have some instruction in the trust that says the intent is to supplement rather than replace or supplant the asset, the public benefits that the child is already entitled to. We have good case law in North Carolina. There was a family years ago that created a trust for their child. And that that trust was challenged by a Department of Social Services that wanted a guardian to be appointed who would have to spend all of the money in the trust uh, before the child would be eligible for Medicaid again. The child was living in a group home. The trust couldn't have even paid a year of the cost of the group home. And the court in North Carolina said that the intent of the parents was that that child be provided for a longer time than just to spend the money uh, on paying the group home and getting eligible for Medicaid again. And fortunately, that trust stood up as a special needs trust, even though it wasn't the best drafted special needs trust. And it's actually one of the better cases around the country um, that we actually have here in North Carolina. Now, if we can't do the third party special needs trust, we might have to do what's called a first party payback special needs trust. That should be only funded with assets belonging to the disabled person. So for example, if a child was in a car accident or was injured at birth due to medical malpractice, that money would be the child's money, and that would have to go in to one of these payback special needs trusts. The other time where it would have to go into that is if you failed to do estate planning to protect those funds. And most of us really don't want government to be our charity of choice. So doing the estate planning is really critical. And our planning is very limited beyond age 65. So it's really critical for older parents to be aware that they need to get around to their estate planning. These trusts can be set up by parents, grandparents, courts, and guardians. And I didn't complete a thought there, it looks like. Uh, Up until recently, the child with a disability couldn't set the trust up themselves. What I've heard from congressional staff members that were around when this law was written is that they accidentally left off the disabled beneficiary. So for years, we attorneys had to go to courts for competent people with disabilities to ask courts for permission when parents and grandparents had passed away. But the person with a disability can do it for themselves, and I'll fix this in the materials before they get posted. So it will say that the person with a disability can do it. The trust has to be irrevocable, and it has to be for the sole benefit of the disabled beneficiary. And that can lead to complications. Um, and because the state is entitled to what's left, the trust are more likely to be scrutinized closely versus the third party trust. And like I've already said, Medicaid payback is always going to be a part of these first party payback special needs trust. Now, how many of you, well, I can't get a show of hands, but there are pooled trusts that operate both third party and first party special needs trust. There are three that I commonly would recommend. Commonwealth Community Trust, which is a national pool trust operating out of the state of Virginia, but they also have a lot of folks here in North Carolina. I do serve currently on their board of directors. Guidance Carolina used to be called Corporation of Guardianship. They're operated out of out of Greensboro, North Carolina, and I use them frequently. And Life Plan Trust operates out of Raleigh, and all three of them operate pool trust that can be third-party trust, but can also be first-party trust. And each, I'd say the benefit of Commonwealth Community Trust is they operate in many states. And so a child that might need to move to another state is more likely to be able to utilize the Commonwealth Community Trust. Guidance Carolina and Life Plan Trust are primarily here in North Carolina, and uh, and have staffs that uh, can provide services to people with disabilities. Uh, I tend to myself use Guidance Carolina for people with mental illness issues because they seem to do a super job with those, but developmental disabilities, they would be able to handle that too. I feel like Life Plan Trust is best for people with developmental disabilities. If in choosing between the three of those, but all three would be good choices potentially. And I would investigate all of them. Um, they are required to have at least 3 participants. All three of these have many more participants than that. The funds of the trust beneficiaries are pooled into a bigger trust, which means that the investments can be handled more professionally. And the cost to the beneficiaries will be lower than potentially if a trust was having to operate that was relatively small. Um, these organizations have trust that are under $100,000, and they have fee structures. Each are different than the other, um, but all could potentially be a choice that could make sense. And you can even plan for using one of the pool trust as part of your estate planning before you pass away, possibly possibly at little or no cost, depending on the one that you would be using. Now, one warning I'm going to give you is that you really want to investigate pool trust and be careful with the choices that you make. There's a pool trust that used to be operating in the state of Florida, um, called the Centers for Special Needs Trust Planning, that is currently in a bankruptcy. And there's been a lot of money that's been lost by families that were participating in that pool trust. Um, and the three that I'm naming here, I personally don't have worries about. But I do think it's important if you search for centers for the Center for Special Needs Trust Administration. If you ask me, what happened there should be bigger news than Bernie Madoff. Um, but it's not really gotten into the press the way that I think it should have. So be careful in making your choices and reassess from time to time. Any of these nonprofits are going to have uh, required filings, including a 990 tax return that they have to file on a regular basis. If you have an accountant, you may want your accountant to look and see how how their 990s look in making decisions. ABLE accounts are not a trust, but ABLE accounts are a way currently for somebody that has a child that's under age 26, that's or a child that became disabled prior to age 26, and starting next year, hopefully under age 46, that they can put a little money aside up to $19,000 per year, plus some earned income if they're working, depending on if the ABLE program has approved of that. It's a way for people with disabilities to save more than the $2,000 that they're typically allowed to have if they're eligible for SSI and are single or eligible for Medicaid, as it doesn't count as an asset for SSI or for Medicaid. The SSI, if you have more than $100,000 in an ABLE account, uh, is temporarily suspended until it's back under that. Currently in North Carolina, uh, you wouldn't lose your Medicaid unless an ABLE account went over $550,000. And that number changes and is based on 529 account limits, which in North Carolina is currently $550,000. What could it be used for? It's best used for qualified disability expenses. Qualified disability expenses include basic food and shelter, transportation, education, advocacy expenses. Um, and education is pretty broad. The IRS is the agency that actually regulates the ABLE accounts rather than Social Security. And Social Security has been pretty liberal in their decisions on what the money can be spent on and would qualify as a qualified disability expense. So for example, it doesn't fit quite into any category, but people with disabilities need to have phones to be able to communicate. So phones and computers, all of those sorts of expenses are qualified disability expenses. So you can really do a lot with an ABLE account. And one thing that I really love about ABLE accounts is for people with disabilities that can make decisions for themselves. It gives them a degree of autonomy to be able to open a savings account for themselves and be able to use those funds and not have to live under the limit of $2,000 for the rest of their lives. So next, next is a discussion of Sally Gardner, or Sally Gardner. Sally is a 18-year-old with developmental disabilities suffering from or having non-mosaic Down syndrome, new to North Carolina. Her parents are concerned about the innovations waiting list and whether she'll be able to get any help. Will she be able to get eligible for Medicaid in North Carolina? My answer is yes. Why? She's 18 years old, so she should be able to get eligible for SSI. She's lucky in a way because she falls into a listing for Social Security, and that listing is for people with non-mosaic Down syndrome. So the diagnosis and the medical evidence that she has non-mosaic Down syndrome is automatically a determination that she should qualify for disability. That's one reason why a lot of my parents that have kids with Down syndrome don't understand what trouble my clients with kids on the autism spectrum go through trying to get eligible for SSI because they fall into a listing. So it can be very easy for certain people to get eligible for SSI and Medicaid and a lot more difficult for other ones. But since she is going to be eligible for Medicaid, what is she going to be able to get here while she's on the innovations waiting list? One is full Medicaid eligibility. Second is early and periodic screening, diagnosis and treatment, or EPSDT, based on being fully eligible for Medicaid and being under age 21. Now, there's also the I waiver. And I know both of the websites of the organizations that are sponsoring me today have good information that will help you get to that if you're not already there. And the other reason why it's so critical that we go ahead and get eligible for that SA is that disabled adult child pass along that I was talking about earlier. Because if Sally's parents were to pass away, it's going to be a lot easier for her to be drawing off of the parents' work history. Now, her parents are probably younger with her just being 18 years old, but you never know when things are going to happen. And now I'm going to say Sally's now 25 and her father's passed away. And at the time he passed away, Social Security calculated that he would have been entitled to $4,000 a month. At this point, assuming that Sally got signed up for SSI the way I would have hoped that she did, uh, would she stay eligible for Medicaid? Yes, because she would lose her SSI check because she would be drawing $3,000 a month in a Social Security check now. She still has to stay under 2,000 a month of resources or assets, but she will stay eligible for Medicaid. And assuming dad passed away, if mom wasn't living, or mom wasn't living, or mom was living, there would be 3,000 additional dollars of income coming into the household, making life easier for Sally and mom, or potentially just Sally alone if uh, if dad was the surviving spouse. Now, assuming she wasn't eligible for SSI, what happens to Sally now? Instead of having an income of $3,000 a month, she has an income of $262. That number in North Carolina has not changed since the existence of Medicaid in North Carolina. It's based on a number from a program called AFDC at the time that Medicaid came into existence, which allowed for keeping $242 when I think Richard Nixon was the president. Plus, Medicaid ignores the first $20 of income. That's where that $262 a month income limit comes from. But this is a recipe for making it very difficult for caregivers to take care of Sally at home. It puts her at much greater risk for ending up in an institution. Now, I'm taking so long. Do we have a lot of questions, Christy?
Hey, Bailey. Yeah, we have 22 questions in the chat. So
Okay.
it's up to
Uh,
you how you want to proceed.
okay, I'm going to try to do the rest of what I have here that I want to mention. But I think these are issues that you guys could help them with too. So
Okay.
here, let's say uh, Sam and Dave, their parents, they have 3 kids. Uh, One is on the innovations waiver. Dave has lost his job and Cobra costs too much. What might be an option? North Carolina has a program called NC HIP, the North Carolina Health Insurance Premium Payment Program, that may be able to help cover the expenses because having the parents' income, uh, having the parents eligible for insurance, keeping the child uh, that's eligible for the innovations waiver potentially able to have that private insurance or the employer insurance could actually save Medicaid a fair amount of money. And so if approved, and not everyone would get approved, the family could qualify for a special enrollment into into the into the employer's insurance. There's even a possibility that you might be able to fix a problem where you might not have signed up for it earlier, and that benefit doesn't just benefit the child, but it benefits the whole family. And I just thought I would bring that up as something that might be a good thing for you to be aware of. I'm going to skip that one. Um, I put a little bit more details in about first party payback trust and able accounts here as well, but that's I've have repeated that. And about some of the changes to Medicaid. I really don't have time to discuss those. I'd rather take your questions. So let's just move on to the questions.
Yep. Thank you so much, Bailey. Okay,
Yes.
so first, really quickly, just so we don't forget about it, I am going to launch a really quick evaluation poll. If you guys wouldn't mind taking just a quick second, I think it's like 3 multiple choice questions. We would really appreciate your feedback. Thank you so much. I'm going to leave that up. So questions, we are going to go to the Q&A. And if you put a question in the chat and you did not put it in the Q&A, if you wouldn't mind jumping over and putting it in there, because we're going to go down this list. Okay, first question. Once a special needs trust is set up and has been in place for a number of years, can it be changed or revoked? For example, the trust was useful when someone is under age 25, but as an adult, an able account may make more sense.
Yes. Well, I'd have to say it depends. If typically, if I do a third party special needs trust, I make it revocable until the death of the parents in order to be able to come back and rewrite it from time to time. And that's normally what I would do. Um, there are sometimes where with a third party supplemental needs trust, I might make it irrevocable, especially if somebody plans on funding it immediately, or if it's being funded by other family members that don't want the terms to be changed. And even then, I try to build in ways that somebody would be given permission to make changes to that irrevocable trust if it made sense due to changes in circumstances. With a payback special needs trust, it's going to be more difficult because that has to be an irrevocable trust. And because Medicaid's interest might be affected, I would probably have to notify uh, Medicaid and the folks that do trust review for them in order to give them a chance to see how we would be modifying that trust. So yes to the third party trust most of the time, if it's drafted well to allow us to do it. For a payback, first party payback special needs trust, probably not, without going through either a court process or through a lot of headaches.
Okay, thank you, Bailey.
Yes.
Next question is, and I think you answered this, but you can give an abbreviated answer again. What steps do I need to take, or what kind of attorney specialty is needed so that I can leave my home as an inheritance to my son, to my soon-to-be adult disabled child, or in a trust, since I do not have a mental abilities for finances?
Look for a member of the Special Needs Alliance or other attorneys who specifically say they do special needs planning. Um, in vetting them out, I would recommend that you see whether they know what the innovations waiver is. Ask them questions to see what they know in order to vet them out. Members of NALA are more likely to have been exposed to special needs planning. And so that would be a good resource to look at. And if anybody can't find somebody, if you notify me, I can make recommendations or even work with people that are not in Winston-Salem. I meet in Durham with families sometime at a firm that I used to be of counsel to. And I've met with people all around the state from time to time in some circumstances, and a lot can be done remotely.
Great, thank you. This
Yes.
next one might need some more context, Monique. I don't know if you want to reword it at the end and we'll try to get back to it. She said, what if you are appealing SSI and your child is 29 and has no work history? But I don't know, maybe you do, Bailey. I don't know what that was in reference to necessarily.
Yeah. Well,
So,
if you're in the appeal, one thing that I want you to be concerned about, and I'm a special needs planning attorney, and that's my specialty. There are other attorneys that are Social Security disability specialists that deal with that appeals process. And so they would be your best resource to talk with. But what I would say is that it's really important what age Social Security determines the disability started. And because the disability starting prior to age 22, even if you weren't eligible for Medicaid or for SSI at age 22, could still mean getting the childhood disability benefit based on the parent's work history later on. So that is something that I would want you to be attentive to. And if your child was disabled prior to age 22, it's important that that be documented. And it's important that your attorney that's helping you with the appeal, and if you don't have an attorney, I strongly suggest you get an attorney once you get into the appeal to an administrative law judge. And uh, if if the disability onset was after age 22, then you would not be able to get to the childhood disability benefit that I was describing earlier. And I don't know of any way to fix that if Social Security doesn't find that, although I have talked with uh, Social Security disability attorneys about being careful to try to get the age of onset of disability down correctly, where it may not look like it's important to the folks at Social Security that see somebody coming in when they're in the appeal at age 29. I hope that helps.
okay, thank you, Bailey. We got about 10 more minutes, so we're going to try to get through as many of these as possible. Okay, next one is, I now receive 100% VA and SSDI. My first child has been denied SSI twice. I now have twins that are disabled. The phone reps never process the SSI application for the twins. They complete the app for my first son and say all are denied due to income. Is that true? Seems like income would be adjusted due to more than one disabled child.
Yeah, I think where this issue is coming in is you're on Social Security disability already. And uh, we're, and this gets really involved and I'm not sure if I'm going to be able to do it justice with the time limit I have. But when a child is under age 18, that's not the childhood disability benefit. That's the child's benefit under Social Security. When the child turns age 18 or no later than age 19, if they're in high school still, uh, that would be when you've got to, for a child with a disability, uh, you have to go through the transition from being a child, where you don't have to be determined to be disabled, to being an adult who has to be redetermined to be disabled, even if they're eligible for Medicaid already because of their disability. And so what I usually tell people, and I usually tell this to lawyers, and don't talk about this to parent groups because it's complicated. But what I suggest is delaying applying for the disability, because if they approve your CDB, your childhood disability benefit, which I think's happened here, and you never were eligible for SSI, you're in the category of the unfortunate people that don't get the disabled adult child pass along. Now, the SNA that I'm a member of, one of our goals is to get the law fixed, because this happens to a lot of folks that have kids that were drawing a check based on a deceased or a disabled parent's work history as a child, not getting information that they've got to get the SSI before they get the childhood disability benefit. And I can't fix it. And I've met with a lot of folks or talked with a lot of folks for free that have children that are disabled, that are still minors, to try to make sure that the parents hear it. And I've got advocates that are hearing this right now that are going to get it out and around. But the national organizations, this is complicated, and it's so complicated that I don't think we're speaking with one voice about this needing to get fixed. But it's a trap, and it's a trap that at this point, I don't know of any way to fix it, except to say that if you have a child with a disability, that you want to delay the childhood disability benefit until you can get the SSI. And if you apply for both SSI and SSDI, from what I've seen, but I haven't been able to put my fingers on it to where I'm 100% comfortable that I understand this. But Social Security judge one time told me that there's a higher priority on approving the SSI. So the SSI gets approved first. So if they approve the SSI and you immediately you lose it because you have the higher check from the childhood disability benefit based on the disability, you could get it fixed potentially. But since you're in the appeals process, it all depends on whether the child would be able to draw that larger check. And I'm afraid what happened is they've already approved the childhood disability benefit. I would suggest talking with at least one or two disability attorneys that do nothing but disability. If they say they're not willing to take the case, that's probably what the issue is. And if if you want to email me, I'll take a look. I might talk with you for a few minutes, just to assess what's going on with you, because I know I can't answer that question.
Yeah. Thank you,
Yeah,
Bailey.
without more.
So we have about 5 more minutes. I'm okay with running a few minutes, like 5 extra minutes over if you
Yeah.
are. I know other folks have to go, but we are recording
Yeah.
this, so you'll see the answers. There's a couple that we answered during the presentation, so I'm gonna skip over those and come back if we have time just to acknowledge them. Next one is there a way to file a complaint or recourse when vocational rehabilitation does nothing to help a young adult? Are there any next steps to get help? Bailey may have a comment on this, but Sandra, if this is the Sandra that I'm thinking it is, you have my contact information and can email me. And yes, that's something that we can help you with. But there's my email address in the chat, just in case it's a different Sandra. Feel free to reach out to ECAC to me, and I can connect you to somebody that can help you with that process. Bailey, I don't know if you have any
I
comments.
don't really have any more comments
Okay.
about that. I think your contacts would probably be the best.
Have a
Eh,
couple of questions. I'm sorry, go ahead, Bailey.
Go ahead.
Couple of questions just in general about amounts to put in NC Able accounts, and do each of
Mhm.
your kids need separate account? So we actually have on our ECAC's YouTube channel a webinar from the folks at NC Able that did a great job explaining NC Able accounts. So I'm going to include that in the follow-up email. And then also a link. I put it in the chat a little bit earlier, but add the link to the ncable.nc.gov website, which also has great information on it. Let's
Right.
see. Are there ways to set up power of attorney to prevent the payback special needs trust?
Yes, yes. Um, the power of attorney uh, that you have probably needs to have gifting powers that would allow somebody, if you became incapacitated, to either fund the trust that you have already set up or potentially to be able to set up a trust. So yes, a financial power of attorney can be worded in such a way that it could be used to fund that type of a trust.
Another question about Able, does setting up an Able account impact SSI? And I'll let you answer.
Yep, yep. The setting up an ABLE account will not be considered an asset for SSI, and it is something that you could do in order to have a savings account of more than the the money in the Social Security uh, account that the child has. Yep. So you definitely can.
Um, if someone already got guardianship due to a wrong recommendation, which happens all the time, don't feel bad.
Yep.
Is it possible to reverse it or change it to limited guardianship?
It's possible to change it to a limited guardianship. And in fact, the administrator of the courts in North Carolina is training clerks on new law and new factors that they need to be considering, and is recommending that that the guardianships be reviewed on a regular basis to see whether they really are necessary. And it may even be possible to declare someone that's been declared incompetent competent again through going through a process. And
Mm.
one thing that I would recommend is the first step is to try to work toward limiting the guardianship as much as possible. And then as you limit the guardianship, have hearings before the clerk, and at some point actually petition the clerk to terminate the guardianship.
Yeah. And darling, I'm going to send out in the follow-up email. I'll send a link to the website, the judicial branch website on guardianship. And if you read through that and scroll down, there's actually a section on restoring competency, and you can actually see the form that you would fill out. So I'll be sure to send that in the follow-up information. Let's see. Must a disabled child be 18 to sign a power of attorney?
Unfortunately, yes, they have to be an adult,
Okay.
but
Um,
they can meet with an attorney before they're 18 in order to assess their capacity to do it. And it could make a wonderful birthday present at age 18.
let's see. We are at time, so I understand if people have to go. But Bailey, as long as you're okay with staying on another 5 minutes or so, I am,
Yeah,
and that way we can
me
go
too.
through these questions and get a couple more
Yeah.
in. What is the Medicaid Estate Recovery Program?
Okay. Medicaid estate recovery is a program that impacts people that are receiving certain types of benefits, mainly nursing facility, assisted living facility, Medicaid, which is special assistance. And they're over age 55, or they've been determined by the state to be permanently institutionalized. And I haven't seen any activity on trying to declare people permanently institutionalized. So it generally only applies in those circumstances. Estate recovery is only recovery against those individuals 55 and older for the most part. But trust recovery is different. So for the payback special needs trust, that's trust recovery. And they recover any Medicaid that the person had since the time they were born. So they're two different things. Um, estate recovery is mentioned in uh, Medicaid uh, qualification packages. So they're letting you know that the estate recovery exists. It's possible that somebody could be considered permanently institutionalized um, based on states going through a process of actually determining that they've been declared permanently institutionalized. But to my knowledge, I've never seen that happen. Um, Christy, have you seen that?
Not personally, no.
Yeah. So for the most part, that becomes an issue just based on the age. Now, in addition to the nursing home, if somebody is on waiver program benefits, um, a lot of those benefits would be covered under Medicaid estate recovery for those older people too. So a child who passed away at 54 might not have estate recovery, but one who passes away at age 55 might. And it could go back and cover a lot of the assets that, so for example, I would not title the house in the name of the child with a disability. I would keep it in the third party supplemental needs trust instead of doing that.
Okay, thank you, Bailey. Let's see. We'll try to get at least two more in. How is a supported decision-making agreement created in North Carolina? Does it have to be registered somewhere? What resources are there in North Carolina to help a family with developing a supported decision-making agreement?
Okay. There's some resources on ECAC's website that I've seen, and it does give some examples, but this is so new. The General Assembly mentioned in changes to the guardianship law about supported decision making, but they didn't pass any legislation at all concerning this. And so for right now, it's whatever you want to put together. And if it's being done in a competency proceeding, the guardian ad litem and the attorney that might have been pursuing guardianship might be able to talk it through and come up together with the person who might have been declared incompetent otherwise with an agreement without having to take the risk of the power of attorney. Um, I've been discussing that with the guardian ad litem, um, and I would be willing to do it outside of the guardianship process if I felt like I had a child that could communicate well enough. But I'd feel a little better if we had a law that created a category of people that that supported decision making could work for. And I have looked at the law in Florida on occasion, and there they create a, a means of the court getting involved quickly in people that have supported decision-making agreements due to intellectual disabilities and developmental disabilities. So the court can intervene quickly without having to declare the person incompetent. And if we could pass a similar law in North Carolina, I think it would make it a very valuable tool versus leaving it to us attorneys to try to work out something.
I also wanted to
So it's a
mention,
work in progress.
it is a work in progress. It is. And it's a good work in progress. You know, guardianship and alternatives, it's a spectrum. So it's not guardianship or nothing. There is a spectrum of
Yeah.
options for folks. And I'm really, you know, thankful for that. And it's something that I'm thinking about as a parent also. My daughter's only 14, but it's coming soon. So it's something we have to think about too. I did want to share that Rethinking Guardianship North Carolina does have a supported decision-making guide on their website. We have also shared it on ECAC's website, and it is in English and Spanish. And if you want to send me an email, I'll include that in the follow-up information anyway. And I have come across some other supported decision-making examples and resources that I can share as well. All right, let's see. Let's do. Are you good with one more, Bailey?
Yes.
All right, let's see. I'm trying to find something that's middle accounts. Okay. Is there any way to get a retirement account such as an IRA and not losing benefits? Or what choices do we have as parents to get a retirement plan for them?
Okay. If the child has their on 401k, it can uh, it can as long as it can't be accessed, it's not a problem, but at some point it will be accessible. And it probably would end up being taxed at that time. One option might be moving those funds over into an into an ABLE account if the person became disabled at an early enough age. Uh, Another option, and if this is your own IRA or your own 401k, you can designate the beneficiary on it to go to your third party supplemental needs trust. And there's also a way if that it could go to a payback special needs trust if it's an inherited IRA. And the IRS has blessed that in private letter rulings on multiple occasions. So there are financial institutions that would be comfortable with that happening. Generally, you can't be the trustee of that trust in order for it to work for the IRS. And you definitely would need some help from an attorney to help navigate that. But so far, they haven't said there's a way to do it with the child's on IRA. And this is a time where they actually said you can put the IRA into the trust. So I hope at some point in the future, they'll allow people with severe disabilities that have earnings to be able to do the same thing that can be done with an inherited IRA. But so far, uh, I've not seen that happen anywhere in the country yet.
Okay, great. Thank you so much. So I do want to say real quick, I've seen in a couple of other questions that people have asked for like financial planner and have questions around financial planning.
Yes.
We are also hosting 2 webinars in July on the top 10 tips for special needs financial planning. So those are definitely posted on our Facebook page. I know because I saw them. I don't know if they're on our upcoming events calendar on our website yet, but they're going to be soon. So always check ECAC's website, go on upcoming events calendar. You can register for those. And we also have webinars coming up in July in partnership with NC Hope on housing and independent living for people with IDD. And I am going to reach out to the NC Able folks again and see if they'll do another webinar for us in the fall sometime. There is one question, Bailey. I don't know if you can answer this or not, but somebody did ask like ballpark amount for a lawyer to set up a special needs trust. Just ballpark realm, because those of us
Yeah,
who aren't don't have zero idea if it's $100 or $100,000, how much it
yeah.
costs.
It could vary greatly, and it depends on what assets that you have. Because there might be tax planning and things involved. I would say, um, probably anywhere from 1,500 to $7,500, somewhere in that ballpark would be fairly typical. Um, I would say that uh, if you've done something on your own, it might make sense to at least go see a lawyer to review it with them to make sure that it would work if you felt like it wasn't within your budget. And if you can set up agreements with pool trust as a means to simplify the process, um, and that might be an option as well.
Great. Awesome. Well, this was fantastic information. It's a super complicated topic and it's a very important topic. Again, we're hosting Bailey again on Thursday evening. Same webinar, same information, and hopefully we can get through all the questions then. I really appreciate Jenny Hobbs with Advocates for Medically Fragile Kids for introducing me to Bailey. Thank you so much, Jenny, and we appreciate your partnership on these webinars. Also, please check out Advocates for Medically Fragile Kids NC website. Like I said, they have fantastic information on Medicaid waivers and such on the website. Bailey, thank you so much. We
Oh,
so
my
appreciate the
pleasure.
partnership.
My
And
pleasure.
we will
And
see you.
thanks for the invitation.
Yes, absolutely. And we will see you again on Thursday evening. All right. Thanks for joining us, everyone. Bye-bye.
Thank you all.
Thanks.
Bye-bye.
Bye.